Good day, everyone, and today we will discuss the criminal procedure from Rule 1110 to Rule 1126. And before we start, by the way, I am Erna P. Isog, and Rule 1110 is the prosecution of offenses. Section 1 is the institution of criminal action. Criminal action, it is the establishing of criminal charge, complaint, or information. This section states that in offenses outside Metro Manila that has more than 6 years and 1 day and above, punishment should be required preliminary investigation. While if the offense punishment is less than 6 years and 1 day, the complaint or information should directly filed at the municipal trial court or the municipal circuit trial court and office of the prosecutor. For offenses in Metro Manila and other chartered cities, the complaint or information should be filed office of the prosecutor. And the Section 2 of Rule 1110 stated that the general requirements of complaint or information are: first, shall be in writing; second, in the name of people of the Philippines; and third, it is against all person who appeared to be responsible for the offense involved. The Section 3 and 4 of this rule define the complaint and information. So what is complaint? Complaint, it is a sworn written statement charging a person with an offense subscribed by the OPP or the offended party, peace officer, and other public officer charged with the enforcement of the law violated and filed in the prosecutor office. While information, it is the accusation in writing charging a person of an offense subscribed by the prosecutor and filed with the court. General rule of duplicity of offense on Section 13 of this rule is that and one information is equal one offense. Exemption is when the law prescribe a single punishment for various offenses. So next is the Rule 111, the prosecution of civil action. According to the Section 1 of this rule, when the criminal action is civil liability shall be deemed instituted. That the general rule, but there is an exemption. First, when the offended party waives the civil action. Second, the offended party reserves the right to institute it separately. Always remember that the reservation shall be made before the prosecution starts presenting its evidences. The third, it is institutes the civil action prior to the criminal action. But always remember the primacy of criminal action over civil action, that even the civil action is instituted first the criminal action, the civil action shall be suspended until the final judgment is rendered in the criminal action. In exchange, the situation when criminal action is instituted first than the civil action, still the civil action is suspended until the final judgment is rendered to the criminal action. So next, we proceed to Rule 112, Preliminary Investigation. According to Section 1 of this rule, preliminary investigation, it is an inquiry or proceeding to determine whether there is an probable cause that the crime has been committed. And the preliminary investigation, it is required to be conducted before filing a complaint or information for an offense where the penalty prescribed by the law as at least 6 years and 1 day imprisonment. The officers allowed to conduct preliminary investigations are provincial or city prosecutor and their assistants, national and regional state prosecutor, and other officer as may be authorized by the law such as the Comelec and the Ombudsman. Certain is arrest. In Section 1 of this rule, arrest is taking a person into custody in order that he may bound to answer the commission of an offense. It is made by an actual restraint of a person to be arrested, or by his submission to the custody the person making the arrest. It shall be the duty of the officer executing the warrant to arrest and the accused and to deliver him to the nearest police station or the jail without unnecessary delay. In Section 4, Rule 113, the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer shall make a report to the judge, and in this case of his failure to execute the warrant, he shall state the reason. Section 5 of this Rule 113, a peace officer or private person allows to arrest person without warrant when first is caught in the act or in flagrante delicto, second, you have the personal knowledge or hot person, and the third one is keep a prisoner. An arrest may be made on any day at any time of the day. 11, police officer must identify themselves and announce their purpose before using force to enter. Apply first the break and announce doctrine. The Rule 114 is bail. Section 1 of this rule, bail is the security given for the release of person in custody of the law, furnished by the ombudsman to guarantee his appearance before any court. Bail may be given in a form of corporate surety, property bond, cash deposits, and recognizance. Section 2 of this rule, all person having an offense can avail bail except those charged with offense punishable by reclusion perpetua, death penalty, and life imprisonment. Section 4 of this rule, bail is the matter of right when before and after conviction by the MTC, Metropolitan Trial Court, and the Municipal Trial Court, and before conviction by the Regional Trial Court of an offense is not punishable by LDR. Rule 115, the right of the accused. The accused in criminal prosecution have several rights, including, first is the presumption of innocence, second, the right to inform the nature and cause of the accusation, the third, the right to be present and defend themselves, fourth, the right to waive their presence and the trial unless specifically ordered by the court, fifth, the accused can testify as the witness on their behalf, sixth, they can confront and cross-examine witnesses against them. 7. The speedy, impartial, and public trial. And last, the accused can appeal in all cases allowed and the manner of prescribed by law. Next is the Rule 116, the arraignment and plea. According to the paragraph A of Section 1 of this rule, the accused must be arraigned before the court where the complaint or information was filed or designed for trial. Arraignment shall be made in open court by the judge by giving the accused with the copy of the complaint and information, reading it in the same dialect known by the accused and asking him whether he pleads guilty or not guilty, and the accused answer it is the plea. Paragraph B stated that the accused be present at the arraignment and must personally enter his plea. According to paragraph C of Section 1 of this rule, if the accused refuses to plead, a plea of not guilty shall be entered for him. Then the paragraph D, when the accused pleads guilty but the presents exculpatory evidence, his plea shall be deemed withdrawn and plea if not guilty shall be entered for him. Rule 117 is the motion to quash or the request for dismissal. On Section 1 of this rule, the accused may move to quash the information or complaint anytime before entering his plea. The motion to quash shall be writing, signed by the accused and his counsel, and shall be distinctly specify its factual and legal grounds. And next is the Rule 118, which is the pre-trial. According to the Section 1 of this rule, pre-trial is mandatory in criminal cases. It is conducted to avoid surprises. During the pre-trial, both parties will lay down evidences, witnesses, because failure to present that on pre-trial it could not be admitted during the trial unless otherwise the reason for it is good cause, and in case that it is objection will be raised, and that is the reason why there is a pre-trial. In pre-trial, there will be a plea bargaining, stipulation of facts, marking of identification of evidence, waiver of if objection to admissibility of evidence, and the modification of order of trial if the accused admits the charge. In Section 2 stipulated all agreements of admission shall meet or entered during the pre-trial conference shall be 1. Reduced in writing, 2. Assigned by the accused and counsel, otherwise they cannot be used against the accused, and non-appearance, accused and counsel, the court may impose proper sanction or penalties. Rule 119 is trial. According to the Section 1 of this rule, the time to prepare trial is after plea of not guilty is entered. The accused shall have 15 days to prepare for trial. Then the trial shall commence within 30 days from the receipt of the pre-trial order. On Section 3, the period of delay shall be excluded in computing the time when delay resulting from other proceeding concerning the accused, delay resulting from mental incompetence, or physical inability for the accused to stand trial, and if the confirmation is dismissed upon motion of the prosecution. On Section 11, the order trial, which first the prosecution shall present evidence to prove the charge. Then the accused and the defense presents rebuttal and rebuttal evidence. Then shall be named submitted for decision. Section 17 is the discharge of accused to be state witness. Happens when there is no stronger direct evidence. The prosecutor will select on one suspect to be witness, or she should not appear to the most guilty. Section 23 is the demurrer of evidence. It was after the prosecution raised its case. The court may dismiss the action on the ground and insufficiency of evidence. So next is the Rule 120, which is judgment. According to the Section 1 of this rule, judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability. Next is the Rule 121, the new trial or reconsideration. According to the Section 1 of this rule, the time of the new trial or reconsideration is any time before a judgment of a conviction becomes final. On the Section 2, the grounds of a new trial, first is the error of law and second is the new and material evidence has been discovered. And Rule 122 is the appeal. According to Section 1 of this rule, any party may appeal from judgment or final order unless the accused will be placed in double jeopardy. And Section 2 is where to appeal. When from first level court or the MTC appeal on RTC. When from the RTC appeal on Court of Appeals, and when from Court of Appeals appeal in PN Supreme Court. So next is the Rule 123. It is the procedure on the Municipal Trial Court. And the Rule 124, the procedure in the Courts of Appeal. And the Rule 125 is the procedure in the Supreme Court. Rule 126 is the seize and seizure. Section 1 defined the search warrant as an order in writing in the name of the people of the Philippines signed by the judge and directed to the peace officer, commanding him to search for the personal property described therein and bring it before the court. The personal property to be seized according to the Section 3 are subject of the offense, embezzlement property, and the use or intended to be used as the means of committing an offense. In Section 7, a search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge. It should be found in Section 4 of Rule 126. In Section 7, police officer must identify themselves and announce their purpose before using force to enter. Apply first the break and announce doctrine. The warrant must be served in the day, unless the affidavit indicates the property is on the person or place, in which case it can be served at any time of the day or night found in Section 9.